All right, all right. Peace to Yahoo, peace to Yahoo. This your man Jonah Bey. We live and direct, of course. Blog Talk tripping. Wouldn't let no one get on, including me. Is this what it is? Is this the new shit? This is what I'm supposed to expect, huh? They really don't want me saying what I'm saying, but I'm still not gonna stop. Yo, people can go back and rehear it that's used to hearing it on Blog Talk or Facebook. Let me see. Let me try to do a live, start the live on Facebook. See what happens. Yeah, they really on some I shut them down, shut them down type shit. You know what I mean? But I never let it get to me. I just keep on doing what I'm doing. Go live. This is why the normally on Blog Talk I would play about 15 minutes of music, wait for everyone to get in before I start. But since Blog Talk bugging, no 15 minutes, so I'm on now. And I actually start my show at 7. It's just that most people only hear it when I start on, social media, which is around 7:15. Right? But it's all good. We can adjust. We're not controlled by, habits. We make our own habits, right? All right, let's hit me going in on law. Go live. Last Wednesday, I was reading a Supreme Court case to you on legal tender, money. What is money? What is not? What is Federal Reserve? What is not? I got it from the Board of Governors of the Federal Reserve System site. So I'm on the Federal Reserve website, and it tells you about a case called Juliard versus Greenman. So what it was saying is the United States tendered Malam $50 in Federal Reserve notes, but Malam refused the notes, asserting that lawful money must be gold and silver. The Ninth Circuit, noting that this matter had been put to rest by a U.S. Supreme Court nearly a century before the legal tender case of Juliard versus Greenman in 1884, rejected the assertion as frivolous and affirmed the judgment. So we're learning about what did they say in that case, right? So I'm back to this. I'm going to start reading. I'm trying to find my place where I was. So I'm going to start at section 2 of the case. It says, when the United States are returned to the Treasury, when the United States notes are returned to the Treasury, they may be reissued from time to time as exchanges of the public interest may require. Section 3. When United States notes returned to the Treasury are so mutilated or otherwise injured as to be unfit for use, the Secretary of the Treasury is authorized to replace the same with others of the same character and amounts. Section 4. Mutilated notes, when replaced according to the law, and other notes which by the law are required to be taken up and reissued when taken up, shall be destroyed in such manner and under such regulations as the Secretary of the Treasury may prescribe. Section 5. Authority given to the Secretary of Treasury to make any reduction of the currency by retiring and canceling United States notes is suspended. So they have 300 million Treasury notes in circulation. They cannot get rid of them. If they take one out, they got to replace it with one. So it's always 300 million treasury notes out there. So when your teachers are telling you there is no money, they're lying or they don't know. Section 6, United States notes shall be lawful money and a legal tender and payment of all public debts public and private within the United States, except for duties on imports and interest of the public debt. Number 7, the Act of January 14, 1875, to provide for the resumption of specie payments enacted on or after January 1st, 1879, the Secretary of Treasury shall redeem in coin the United States legal tender notes then outstanding, and on their presentation for redemption, see the word redemption, redeeming Federal Reserve notes for Treasury notes. It's not called set off. It's not called a discharge. The law right here told you what it's called. It is called redemption. You are redeeming things. Take this away and give me what I'm supposed to have, Treasury notes. This is what y'all got to learn how to do. See, my workshop on December 31st is going to show y'all how to do that 100% by the law. I'm giving you the background of the law right now as the weeks comes up to that date, so you can understand what I'm saying when I show you the method, right? But let me go on. It should be redemption at the office of the Assistant Treasurer of the United States in the city in the sum not less than $50. Authorize him to use for that purpose any surplus revenues in the Treasury and the proceeds of the sales of certain bonds of the United States, 18 ST 296, the Act of May 31st, 1878, 146, under which the notes in question are reissued, is entitled an act to forbid further retirement of United States legal tender notes, and it acts as follows. From here and after, the passage of this act shall not be lawful for the Secretary of Treasury or other officers under him to cancel or retire any more of the United States legal tender notes. And when any of the said notes may be redeemed, redeemed, or be received into the Treasury under any law, it has to be under law though. Y'all can't make your own process. Y'all got to use the law to redeem or do the redemption. The law is telling you this. This case law is telling you this. But let me go on. From any source whatever, and shall belong to the United States, and they shall not be retired, canceled, or destroyed, but they shall be reissued and paid out again and kept in circulation, provided that nothing herein shall prohibit the cancellation and destruction of mutilated notes, and the issue of other notes like denominations in their stead, as now provided by law. All acts and parts in conflict wherein are hereby repealed. 20 ST 87. So, even in Lincoln's time, they told you all that. This was how they made the greenback that Lincoln made, which were Treasury notes made by the Treasury, but it was paper, legal tender. And they've been acting on this law in this case ever since. None of the teachers is explaining this to you, but I will. All right, part 8. The manifestation intention of this act is that the notes which it directs after having been redeemed to be reissued and kept in circulation shall retain their original quality of being legal tender. The single question, therefore, to be considered, and upon the answer of which the judgment to be rendered between these parties depends, is whether notes of the United States issued from the time of war under the acts of Congress, declaring them to be legal tender and payment of private debts, and afterwards, in the time of peace, redeemed and paid in gold coin at the Treasury, and then reissued under the Act of 1878, can, under the Constitution of the United States, be a legal tender in payment of such debts. Upon full consideration of the case, the court is unanimously of the opinion that it cannot be distinguished in principle from the cases hereforto determined, reported under the names Legal Tender Case 12 Wall dot 457 Dooley versus Smith, 13 Wall, and 604 Railroad Co. versus Johnson, 15 Wall 195, and Maryland versus Railroad, 22 105, and all the judges except for Mr. Justice Phil, who adheres to the views expressed in the dissenting opinions in those cases, are of the opinion that they were rightly decided. So I just read to you out of this case, it named 5 more cases that told you Treasury notes is lawful money. Treasury notes. I don't think y'all really understand the difference between Treasury notes and Federal Reserve notes. But I will break it down. Number 9. The elaborate printed briefs submitted by counsel in the case of opinions delivered in the legal tender cases in the earlier cases of Hepburn versus Griswold, 8 Wall 630, which those cases overruled, forcibly presents the arguments on either side of the question of the power of Congress to make notes of the United States a legal tender in payment of private debts without undertaking to deal with all those arguments. The court has, though it fit that the grounds of the judgment in the case at bar should be fully stated. No question of the scope of extent of the implied powers of Congress under the Constitution can be satisfactorily discussed without representing much of the reasoning of the Chief Justice Marshall in the great judgment of McCullough versus Maryland, 4 Wheat 316, by which the power of Congress to incorporate a bank was demonstrated and affirmed, notwithstanding the Constitution does not enumerate among the powers granted that of establishing a bank of creating a corporation. 10. The people of the United States. See, now what this case is really doing is breaking down how Congress had the right to create corporations and banks do certain things because it wasn't stopped by the Constitution. The Constitution didn't forbade them from doing it. This is the system that we're in right now. 10. The people of the United States by the Constitution establish a national government with sovereign powers, legislative, executive, and judicial. The government of the Union, said Chief Justice Marshall, though limited in its power, is supreme within the sphere of action, and its laws, when made in pursuance of the Constitution, from the supreme law of the land, among enumerated powers of government. We find the great powers to lay and collect taxes, to borrow money, to regulate commerce, to declare and conduct war, and raise and support armies and navies, the sword and the purse, all the external relations, and no inconsiderable portion of the industry of the nation, and are entrusted into its government. 4 Wheat 405-407 through 407. A constitution establishing a frame of government, declaring fundamental principles, and creating a national sovereignty, and intended to endure for ages and to be adapted to the various crises of human affairs, is not to be interpreted with the strictness of private contract. The Constitution of the United States, by the apt words of designation of general description, marks the outlines of the powers granted to a national legislator, but it does not undertake with the precision of detail of the code of laws to enumerate subdivisions of those powers or specify all the means by which they may be carried into execution. Chief Justice Marshall, after dwelling upon the view as required by the very nature of the Constitution, by the language of which it is framed, by the limitations upon the general powers of Congress introduced in its 9th section of the first article, by the omission to use the restrictive term which might prevent its receiving a fair and just interpretation, added these emphatic words. In considering the question, then we must never forget that it is a constitution we are expounding. 407, see also page 415. So this shit is long as fuck. I'm going to try to find the part that I want y'all to know. Because a lot of it is saying the same thing. All right, I want to read this one because a lot of you patriots talk about y'all got an estate and stuff like that. So let's read this part. Section 18. By the settled construction of the only reasonable interpretation of this clause, the words necessary and proper are not limited to such measures as are absolute indispensably necessary, without which the powers granted must fail of execution, but they include all appropriate means by which conducive or adapt to the end of the accomplished, and which, in the judgment of Congress, will most advantageously affect it. The clause of the Constitution which declares that Congress shall have the power to lay and collect taxes, duties, impose excise, to pay debts, and provide the common defense of the general welfare of the United States, either embodies a grant of power to pay the debts of the United States and proposes and assumes that the power as inherent in the United States as a sovereign government, but in which aspect but in whichever aspect it be considered, neither nor any other clause of the Constitution makes any mention of the priority of the preference of the United States as a creditor over all the creditors of the individual debtor. Yet, this court, in the early case of U.S. versus Fisher, held that under the power to pay the debt of the United States, Congress had the power to enact that debts due to the United States should have that priority of payment out of the estate of insolvent debtors, which the law of England gave to debts due to the crown. See, y'all living under that system right now. They got y'all as bankrupt debtors. And they say the bankrupt debtors have to pay the debt of the United States, right? And then the United States, in this case law, tells you the United States has to pay England. This is why your tax dollars collected every year here goes off to England. It's right in this damn case, coming from the 1800s. This is the truth, y'all. You know, some of these people just give you their opinions or they give you what they heard, but they're not actually looking and reading the documents to prove, what they can and can't do. It's all there for you to read if you was to read and study. I'm showing you now. Yo, first of all, Mur the Day, get out of my chat talking about who wants to get ISO ready. Yo, go create your own live and talk about that in your own live, brother. Stop taking away from what I'm teaching right now. I appreciate it. All right. So Let's go on. Yeah, you said, damn, Brother Truth is on point about England. Yo, check it. I'm reading it to you. It's not my truth. It's in the actual case. Juliard, the Juliard versus Freeman case. This is, their information. I'm just showing y'all the truth of where it is. This ain't my information. All right. Ascar Bay, what up? Yeah, Mount Vernon in the house. Mount Vernon in the house. Okay, let me go on. In delivering judgment in that case, Chief Justice Marshall expounded the clause giving Congress the power to make all necessary and proper laws as follows. In construing this clause, it would be incorrect and would produce endless difficulties if the opinion should be maintained that no law was authorized which was not indispensably necessary to give effect to be specified power, where various systems might be adopted for that purpose. It might be said, with the respects to each, that it was necessary because of the end, in the end, might be obtained by other means. Congress must possess the choice of means and must be empowered to use any means which are in fact conducive to the exercise of power granted by the Constitution. The government is to pay the debt of the Union and must be authorized to use the means of which appear itself the most eligible to the effect of that object. So they're saying we got to create paper money to be able to pay the bills. We got to save the gold and silver to pay foreigners because treaties were done in gold and silver at that time. But the internal stuff could be promissory notes, i.e., greenbacks. But you still had the option of turning in those greenbacks, doing a redemption and getting gold and silver. See, the thing is, they moved the goalposts. They hid how to redeem for lawful money from y'all. And they started hiding it right now from the 1800s. They walked you down this road until now, today, y'all own nothing because of what they did with the money. Y'all own nothing. And you will be happy. I don't know about y'all. I'm not happy. I own nothing. But in a way, I am happy. I own nothing because I created an express trust. And I take all my stuff and I donate it to my express trust. And the express trust has a allodial title. And I make sure if the trust is buying anything, the trust is buying it with treasury notes. I own everything. I don't pay taxes. People who listen to me and study with me don't pay taxes either. If y'all are listening and y'all paying taxes, y'all got a job and y'all paying taxes, shame on you. Indians shall not pay tax. Not that we were Indians, that's something they called us. We were Moors, indigenous, aboriginals, Egyptians. It's many names we went up under from the ancient times, but we shall not pay taxes. So if you don't want to pay taxes, go to jonahdbey.com and look for the W4T workshop. I show y'all how not to pay taxes on your job. Hell, you don't even have to pay taxes on your motherfucking house if you understand the law, because everything is done by law. The problem is y'all don't know any laws and y'all be trying to do things without laws. You know what I mean? Hold on, I'm gonna do a quick little lesson right here, right now, because that's how I get down. I'm gonna take y'all to 26 CFR 31.3402. Because I really want y'all to know how to get out of paying taxes. Because right now, with the economy being the way it is, that's like y'all getting a 30%, 33% raise in the money that you're bringing home if you're not paying anything. got thousands of people that's not paying taxes and thanking me they got that remedy. Now, the funny thing is I created that remedy and shit, I don't even work. It wasn't for me. I did it for y'all. I did the studying so y'all could do it. So when y'all get to this law, it says voluntary withholding agreements. Do you know your bank, that you got a bank account, has a voluntary withholding agreement with you? Every place that you doing business with did a voluntary withholding agreement with you. You went and bought a car, the bank that did that put one in, right? Your job, they put that in. They got a W-4, right? They got all types of voluntary withholding agreements. But what I want you to know is this is the law that tells you that taxes are voluntary. And you had to do a contract to allow them to do it. This very law tells you how to get rid of the contract that you did to allow them to do it. Right? So, wow. Wow, D. Wow. That's all I got to say. Wow, D. All right. So you go down to section 2. Section 2. But you're gonna have to know how to do a proper affidavit, bro. And y'all don't know how to do a proper affidavit by law. Y'all been doing affidavits according to what people tell you to do on the internet, whatever. That's not the proper way. They got a law to tell you, 2 laws that tell you how to do a proper affidavit. So let's read number 2. Let me read number 2 to you. An agreement, which is the withholding agreement, under section 3402 P3A shall be effective for such a period as the employer or employee mutually agree upon. So they're saying you have to agree with the employer for them to be able to take taxes from you, or the bank for them to take taxes from you, right? However, either the employer or the employee may terminate the agreement. That means either one of y'all can terminate the agreement. You're going to terminate the agreement because the money's from you. Prior to the end of such period, by furnishing a signed written notice to the other. That means you got to write an affidavit to the person who's taking taxes and tell them, pursuant to this law, you don't agree. You ain't voluntarily giving taxes to no one anymore. All right, let me go on. However, either the employer or the employee may terminate the agreement prior to the end of such period by furnishing a signed written notice to the other, unless the employer or employee agree to an earlier termination date. The notice shall be effective with respects to the first payment of the amount in respects of which the agreement is effective, which is made on or after the first status determination. So it goes in effect immediately when you get it to them. See, I don't bullshit. This is why they shadow ban me. This is why they don't want me teaching y'all. This is why they go so hard trying to stop me from doing my webinars, my workshops, and teaching y'all, because I teach y'all by what they say. I use their laws to get you remedy. Remedy is when it works. Remedy is, dude put it in the chat and on Telegram. Yo, look at my chat. 000 Medicaid, 401k, everything was 0. He got the full amount. Happy as hell. Thousands of people I showed to do that. Thousands of y'all, I'm going to show y'all how to do redemption of Federal Reserve notes, which means you won't be paying bills no more. You'll be living for free. How does that sound to you? You'll be able to just collect. You just be able to collect your money from work and stack that money. You won't be needing it to live. Oh, well, Jonah, what about my food and all that? Easy. Take your credit card, buy your food, and do redemption on the credit card bill. Everything you're going to buy on credit. Your credit's going to go off the stratosphere because everything's going to be paid by you with treasury notes. It's going to zero it out. What does that mean, Jonah? Well, every time you use a Federal Reserve note, right, it is what they call a debt instrument. So it's a minus. So if you got a $100 bill, that's really a minus $100 bill, minus, which means it goes back to the Treasury as what y'all call the national debt, minus 100, right? So when you know how to do redemption, you give up a positive 100. So when you put the positive 100 with the negative 100, everything is zeroed out. That's called redemption. Zero out. Everything will be zero. You don't owe nothing to them. They don't owe nothing to you. It's zeroed out. It's nothing but accounting. You got to zero out the books. You have to become what Minnesota Rule 220 said. The age of majority when it comes to this banking stuff. You're going to have to know how to conduct your business properly. When you know how to do redemption, you could have a case. When they give you a case, they said they gave you a charge. A charge, have y'all ever looked up the word charge? A charge is a bill. You know how to do redemption. You can redeem any charge, any bill. You don't have to even go to court. You just redeem it. But since you don't know how to do redemption, what they do is create bonds and all that and make you liable. They sell them on the stock market and make you liable for the taxes. Everything in the public is nothing more than a tax. It's a tax because you are not redeeming, which means you are an enemy of the state. Right? Enemies of the state. That's what you're looking at. So these are laws y'all have to know and enforce. But y'all got to know y'all got to do that. Ooh-wee. Yo, y'all out there on TikTok, 3,600 people listening right now. Crazy. You know they trying to shut down TikTok. I already went into something called 8. I forget the name of it, 8 something. But let's see if that happens. All right, let me start reading some of the questions. Y'all already started hitting the ones, saying y'all like it. I appreciate that. Try to combat this AI with the shadow banning. Someone said, and you're right, brother. Tell them all checks 12 USC 411 payout and lawful money. Yeah, it is the law. Y'all really need to comprehend 12 USC 411, 12 USC 412. It goes along with the case I was reading to y'all tonight. Jason Cranfield, what does that do for you? Thank you for your efforts towards helping others gain access to the creative knowledge that you acquired over your years. No problem, Jason. I appreciate you acknowledging it took years for me to get this. Oh, someone asked me what was I reading from. What up, brother? Uric, I'm glad you out of jail. Glad to see you back with us. In the whole nine. I was reading the legal tender, one of the legal tender cases, Juliard versus Greenman from 1884. Juliard versus Greenman. Do y'all know, according to that case, if y'all get a check from the government, like they gave you a tax return check, that was lawful money. It was made by the Treasury. It was lawful money. Now, did you convert that money into Federal Reserve notes? I think you did, because you asked them to give you Federal Reserve notes when you cashed it by not knowing the laws. That's what's going on. Is that their fault or your fault? I know Marlon Walker because I've been studying this for a long while and know some stuff and seen it affect by using this U.S. code on the business to keep them in deep check, brethren. Well, you're going to know way more. You don't even know the half. And that's what Marlon is, my moderator in the chat. So he already knows what you're going to learn and how crucial it's going to be. Because, brother, if you're making any payments to anyone, you need to be on that workshop. You got more to learn. Just because we know things, we can always learn more. We can always do more. We can always become better. You know what I mean? Can you state the citation again for Title 26? Oh, damn. You wait till I close that shit out. Ask me for that again. All right. Jesus. It's 26 CFR 31.3402. And it's for withholding agreement. The law is called withholding agreement. Voluntary withholding agreement. All right. Once again, 26 CFR 31.3402. You don't have to pay taxes. You don't have to agree. Y'all know, y'all could even send the letter on pursuant to 26 CFR 31.3402 to the IRS and saying, I'm not paying no taxes. Legally. Dum, dum, dum. Just put your thinking cap on how to utilize it. I went to the Mercedes-Benz dealer with my 9.8, and Cobb told them I was going to pay out the trust, the fund, and they wrote up a finance contract, which they signed, not me. There was an 11-digit number, VIN. Do they sell my Cobb? Are you? I don't know. What is a Cobb? You mean why didn't you say did they sell your BC or some shit like that? Why y'all always trying to make up y'all's? Why do y'all even use acronyms? I never liked y'all using that acronym Cobb for a birth certificate. And if you're going about trying to get a car that way, You don't know banking. You don't know how to do redemption. You don't know what you're doing. You might catch a public charge. They tell all that seek that the true info in the IRS manual, all taxes are voluntary by choice. Of course it is. But you still have to know the actual law I just gave you to come out of it. Once you volunteer, once you make a deal with the devil, it's very hard to get out of a deal with the devil unless you know what if you do what the devil tell you to get out of it. I like that the law doesn't even require you to explain why you are terminating prior withholding agreement. You can just terminate it if you don't agree. That's fly. Yes, it is fly. It is fly. You ain't lying, Yokon, and you already did it, so you know what it is. That's another satisfied customer. I was shocked when I did that workshop, W4T workshop. It wasn't nearly enough people on it. It was only like 100 people, right? 100 and change. But I've been watching people buy that workshop from my website. So it's way more people that bought it afterwards. And ain't nothing wrong with that. You ain't got the money right now. Put it on your refrigerator saying, when I get the money, I'm going to buy it. And you go buy it. So you could say, me, myself, I would borrow money to go get it so I could make more money on my job. I'd be a better father, better husband, better boyfriend, whatever, with more money. I could learn more things with more money. Someone said the postal master never pay no bills or taxes. Once you know banking and you know redemption, no one that knows that pays any bills or taxes. You don't pay taxes on lawful money, right? Can't pay taxes on lawful money. So the thing that's making you suffer, and by the way, if you owe people money, you know that's a sin. According to all the spiritual books, that's sin. Owing a debt is sin. So y'all all are very sinful. So if you want to not be in sin, you have to eliminate the debts. Marlon said, Nicole Williams, I know some people who say that you don't have to authenticate, which is incorrect. Right. You want to listen. The birth certificate is the actual certificate of ownership of the juristic man, the straw man. Right. It is the ownership, the stock. Now, when you get it from wherever you get it from, I guess mine's from City Hall in Yonkers, New York. I was born in a hospital and I go to City Hall. Shit cost me about $2. Most of y'all be getting it from what's the name of that company they hired to give everyone their birth certificates? Damn, what's the name of that company that gives y'all birth certificates? It's a subcontractor. Vital Statistics. Thank you, Jet Bay. Vital Statistics and Vital Check. It's the same company. Yo, them niggas charge you about $50 to $100 for something that costs $2, B. And it's a copy. When they give you it, it's a copy. It's not original. So therefore, you have to get the signatures of the notaries on that document They don't call him a notary. What they call him on that document? What's the name of the notary on that document? Anyone? Anyone gonna tell me? I know y'all know. The registrar. Thank you. The registrar is nothing but a notary. You got to get that person authenticated. Then you got to get the Secretary of State authenticated. Then you take it up to Washington and get that Secretary of State authenticated. Now you have an original document, not because Jonah said so. When you get the authentication back, there's going to be laws on the front cover page on the left-hand side. Look up the laws and read it. It's going to tell you it's original now. Once you got the original, now you can claim ownership and put it into your express trust. Now you can challenge them for ownership. The only thing that extinguishes a UCC is the actual title. And now you got a title. Well, Jonah, I ain't do no UCC. Well, who was talking about you? I wasn't talking about you. The government did a UCC. Y'all know what part of the government did the UCC on the straw man? Come on, I know y'all know that. I'm looking for any of y'all to give me the answer. Man, maybe y'all don't know. No, not the county. What? Well, the county might have did a UCC, but we know for sure it was Agriculture Department, right? UCC on all U.S. citizens, aka 14th Amendment citizens, aka strawmen. Strawmen. So the only way to get rid of the UCC that the Department of Agriculture put on your straw man is to authenticate the birth certificate and give it to your trust. And they say the birth certificate is annexed away from the United States in law. The law is on the authenticated birth certificate. See, people tell you don't have to do that. Oh, you're making a contract with the government that you didn't have. They bringing you back under the United States. Authenticating your birth certificate according to law has the exact opposite effect. Exact opposite. This is why y'all need to stop listening to people and listen to the laws. If a motherfucker can't tell you what the law is, he's lying. Whether he knows it or not, he's lying. All this shit is written in laws. The problem is y'all don't know the laws. That's where I come in. Yo, you can go to my website and get a webinar I did in 2014 called Privatization. I break all this shit down. Go to jonahbey.com, pick that up, right? I break all that down. The goddamn webinar is like 6 hours long, right? So, authentication is absolutely necessary. Not because I say so. Now, what you mean, Jonah? Yeah, we understand that the Lord says it becomes original, but why I got to do that? Who says that it gets rid of any UCC? The UCC tells you that. UCC 9. Let me see if I can find it. UCC 9 dash, I think it's 312, 313, 311. It's been so long. Okay, it's not 312. Let me look at the next one. Okay, 313. When possession by delivery to secure parties perfects security interest without fouling. So it says, A, perfection by possession or delivery. Except as otherwise provided in subsection B, a secure party may perfect a security interest in a negotiable documents, goods, instruments, money, or tangible chattel paper by taking possession of collateral. A secure party may perfect security interest in a certificated securities by taking delivery of certificated securities under section 8-301 of the UCC. So number one, if you got the certificated security, you have possession. You got perfected interest, which means if you turn the copy into the original certificated security, the birth certificate, you got possession, right? But this ain't the one I'm looking for. But it still broke down. If you authenticate, you have it. Let me go into 311. Okay, it is UCC 9-311. Perfection of security interest in property subject to certain statutes, regulations, and treaties. A. Now, I'm going to read it slow. Pay attention to this. A security interest subject to other laws, except as otherwise provided in subsection D, the filing of a financial statement, which is a UCC 1, is not necessary. It's not necessary. Or effective. Effective. Hold on. What is effective? What does that mean? Let's look up the word effective. I don't want y'all thinking I'm making shit up. I want y'all to know facts from fiction. Effective meaning: successful in producing a desired intended result. Successful, effectual, productive, fruitful, constructive. And that's an adjective. The second adjective is fulfilling a specified function in fact, though not formally acknowledged as such. Then, as a noun, effective means it will actually work. It's essential to make it actually work. Right? So, it said a UCC 1 is not going to work. It's not necessary and it's not going to work to perfect security interest in property subject to, number one, a statute, regulation, or treaty of the United States whose requirements for a security interest obtain priority over the rights of a lien creditor with respects to property preempt section 9-310. What it's trying to tell you is, and I'm going to keep on reading because it's going to make it more plain. 2, list any statute covering automobiles, trailers, mobile homes, boats, farm tractors, and the like, which provides a security interest to be indicated in a certificate of title. A certificate of title as a condition or result of perfection in any non-UCC Commercial Code Central Filing statute. So it told you right there in number 2, if you have the title, no one with a UCC will be necessary or effective to work against you when you have the title. So when you go and authenticate the birth certificate, you have the actual title. And it doesn't matter that the agriculture department of the United States has that UCC. It's not effective or necessary. It won't work. That's law that's telling you that. See, these motherfucking teachers out here, social media, don't understand the laws, don't read the laws to you, don't break the laws down, And this is why y'all don't get the remedy that y'all supposed to get, where the people who listen to me get the actual remedy and it works the way it's supposed to work, because they have put laws out to tell you how to do it. Now, is the laws difficult to read? Yeah, they're difficult to read. They're written in legalese. It's written in legalese. I'm not going to say that it's not. Of course it is. That doesn't change the fact that if you finally read it and comprehend it, it will work. So that's what I bring to y'all. What works, right? So when I say, and I showed you in the case law today, that when you want lawful money, it's called redemption. I'm going to show you by the law how to redeem the money, which is going to make it where you don't pay no bills. I already broke down on this show how to go without no taxes. You don't have to put zero dependence on your W-4 and then 2-3 years down the road, the IRS comes after you, puts a lien on you and takes all your shit and be taking your whole check, garnishing your whole check. You don't have to do that. All you have to do, go to jonahdbey.com and pick up the W4T workshop, and it will show you exactly how to do it and come out of paying taxes. And then you can give it to your kids, your mama, your daddy, your girlfriend, your cousin, whoever. It's up to y'all to do it. All right, so with that being said, it's 8:05. It's time for me to eat. I hope y'all enjoyed the show tonight. I know I did, even though we couldn't be on Blog Talk. I'm sure y'all learned a lot. With that being said, peace to Yahuwah. I'm out of here.